Good evening. Welcome. Myself, Rodolfo D'Souza, founder of MyNation Hope Foundation. Thank you for joining us today and every Sunday. Today we don't have Man Ki Baat. We are covering only legal issues today. Let me tell you about MyNation. We are the largest men's right organization. We have almost 10,000 members registered with us, more than 10,000. We are active online for last almost 20 years. We helped and guiding for free. We are not charging anyone any money. We are sharing our knowledge and helping others. Those who are interested to join us, please visit mynation.net, and there are contact numbers and how to register and other guidelines. Please follow, you can join. Today we are covering about cross-examination, so only, and we are taking questions also. If you have any questions about your case, it's not only about cross-examination, any related to your case, you can post it on YouTube chat window. So we'll take it from there and we'll answer. Hereafter, Dr. Vikas Singh will take over. Dr. Vikas Singh, please continue with the webinar.
Thank you, Rudis, for intro, and welcome everyone. Today we are going to have webinar on essential of cross-examination. So this webinar will be given by Dr. Sarvapalli Prasar. He is a dentist turned legal consultant, currently pursuing his final year LLB. He has special interest in matrimonial matters and Muslim law. So I'd like to welcome Mr. Sarvapalli Prasar to start his presentation. Thank you, everyone.
Thank you, Dr. Vikas Singh Rawat and Mr. Rodolfo D'Souza for the wonderful introduction. I always wait for an opportunity to share my knowledge and parallelly get the feedback so that I can improve myself in the process. Well, this webinar today is the first of a series of webinars that will be catering to, or that I will be catering on cross-examination. Dr. Vikas Singh, please. Well, as usual, this is our disclaimer. The content on this site, including free advice, etc., is provided by users for your personal information only and is not intended for trading purposes or carrying out legal proceedings. As usual, let me repeat the same advice that I give to viewers on this webinar. Never use this without use the data and ideas that we give you here without checking with your counsel or without using your discretion. As usual, MyNation expressly disclaims all warranties expressed or implied as to the accuracy of any content provided. This is for information purpose only. MyNation Hope Foundation does not claim any copyright on any of the articles. Next slide, please. So today I will restrict myself to section 137 and 138 of the Indian Evidence Act, or relevant sections of Indian Evidence Act, section 137 of Indian Evidence Act. So the series of examinations is the series in which it happens is, first of all, there is an examination in chief. What is examination in chief? Examination of a chief is the examination of a witness by the party who calls him shall be called his examination in chief. What is cross-examination? The examination of a witness by the adverse party, which is the opposite party, shall be called as cross-examination. Re-examination, the examination of a witness subsequent to the cross-examination by the party who called him, shall be called as re-examination. Next slide, please. Order of examinations. Witness first shall be examined in chief, then if the adverse party so desires, cross-examined, then if the party calling him so desires, re-examined. Examination and cross-examination must relate to relevant facts. See, the thing is, first of all, there is this. First of all, there is a case of 498, for example, and then if the cross-examination is done on succession on completely irrelevant topics, does it make any sense? No, right? The same thing here. Examination and cross-examination must relate to relevant facts. But cross-examination need not be confined to the facts to which witness testified in his examination in chief. This is very, very, very important, because the opposite counsel, when you're cross-examining, will say, Your Honor, this is not mentioned in the chief examination. Why is he asking it? Why is the counsel asking it? Or why is the party asking my witness, asking my client? Cross-examination need not be confined to the facts to which witness testified on his examination in chief. Direction of re-examination. Re-examination shall be directed to the explanation of matters referred to in cross-examination. And if new matter is by permission of the court introduced in re-examination, the adverse party may further cross-examine upon the matter. Next slide, please. Why should you cross-examine? It has a twofold object. One is impeach the image and credibility of the witness. That's the most important point. The purpose of cross-examination is to show to the court that the witness is not trustworthy. You cannot believe the witness. The witness, whatever the witness told, is a lie. Expose inaccuracy that may be found in evidence. There's a case law where the defense fails to challenge the relevant facts stated by the prosecution witness in the examination in chief. The court may take it as acceptance of the truth of such facts. Relevant case law, Ganesh Jadhav versus State of Assam. So, if you are the defense counsel, make sure that each and every sentence which is vital to that particular section is ripped apart in the cross-examination. Make sure that you don't leave any fact challenge, any relevant fact challenged in the cross-examination, is left unchallenged in the cross-examination. You have to challenge each and every relevant fact and make sure that the image and credibility of the witness is taken care of, is impeached. Next slide, please. Cross-examination is considered as the most powerful weapon. It is a double-edged sword. If you know how to use it, it can help you cut your it can help you cut your enemy's neck. If you don't know how to use it, it will cut your own hands. There are two methods of cross-examination: patient method, aggressive method. Next slide, please. Most important things in cross-examination: patience, preparation, presence of mind. You should know what not to ask. If you don't know the answer to a particular question, don't ask it. Be prepared. You have to be patient. Observe the demeanor of the witnesses. Look into the eyes of the witness when you cross-examine. That is the best way of establishing a communication. Don't intimidate the witnesses, but you make sure that the witness knows that you're serious about what you're talking. Cross-examine with a smile on your face, but don't make it look silly, right? You should know where to stop and what not to ask. Once you get the answers that you want, stop cross-examining. Don't cross-examine further. Cross-examination is not a show off. It's not a reality show to show your talents. You write down what is your purpose, and once your purpose is accomplished, stop cross-examination. Next slide, please. Words of Justice Hawkins. When Justice Hawkins was asked what was the secret of his success in cross-examining, he replied, patience. He says, when you ask a question in a friendly manner with all the courtesy, answer given by the witness amounts to placing a brick at the place of his feet. Then another question and answer to it amounts to placing of another brick. As many question and answers to them amount to placing a number of bricks around the witness. Slowly gain the trust of the witness. Deception is a strategy of cross-examination. Slowly gain the trust. Slowly start asking questions. Slowly, very slowly. Never be in a hurry when you're cross-examining. Make it very slow. When you complete the cross-examination, the brick wall rises around him and the witness is trapped in it and cannot get out of it. Next slide, please. Paul Brown's Golden Rules of Cross-Examination. The 9 golden rules do contain many useful and valuable suggestions. Rule 1. Except in indifferent matters, never take your eye from that of the witness. This is a channel of communication from mind to mind, the loss of which nothing can compensate. If the witness is indifferent, that's a different matter. But establish an eye-to-eye contact with the witness. Look how the witness is reacting is behaving in the courtroom. Are there any change in the way the witness is behaving? You will know all these things. If you know that the witness is lying by looking at the way his eyes are reacting. If the witness is lying, he cannot hide it. It will be visible in his eyes. Use that. Use the eye contact for understanding the witness. And then you can act accordingly. Rule 2. Be not regardless either of the voice of the witness. Next to the eye, this is perhaps the best interpreter of his mind. See, a person lying will not show the same frequency of the same voice modulation as a person who is telling out the truth. The very design to screen conscience, the mental reservation of the witness is often manifested in the tone or accent or emphasis of the voice. Rule 3. Be mild with the mild. Shrewd with the crafty. Confiding with the honest. Merciful to the young, frail or the fearful. Rough to the ruffian. And a thunderbolt to the liar. But in all this, never be unmindful of your own dignity. Never, ever, never lower your dignity before the witness. Bring to bear all the powers of your mind, not that you may shine, but that virtue may triumph, and your cause may prosper. Next slide, please. Rule 4. In a criminal trial, so long as your cause stands well, ask but few questions and be certain never to ask any of the answer to which, if against you, may destroy your client, unless you know the witness perfectly well. Know that his or her answer will be favorable equally well, or unless you be prepared with the testimony to destroy him or her, if the witness plays traitor to the truth and your expectations. So ask few questions in a criminal trial, and don't ask the question which may go against you. If the question to which the answer may go against you. Rule 5. An unequivocal question is almost must to be avoided and condemned as an equivocal. An equivocal question is almost as much to be avoided and condemned as an equivocal answer, and it always leads to or excuses an equivocal answer. Singleness of purpose clearly expresses the best trait in the cross-examination of witness. Always ask leading questions. Now, what is a leading question? A leading question is something that can be answered with a yes or no. You don't give a chance to the opposite party, to the witness to explain his position. No, never give an opportunity to the opposite party explain their position. As much as possible, post questions that may be answered with either yes or no. Falsehood is not okay. Singleness of purpose clearly expresses the best trait in the cross-examination of witness, whether they be honest or the reverse, which means even if it is a lie. Falsehood is not detected by cunning, but by the light of truth, or if by cunning, it is the cunning of the witness and not of the counsel. If the witness is lying, you don't use your wit to show that they are truth. It is truth. It is false. Attack it with relevant evidence to the contrary. Next slide, please. Rule 6. If the witness determines to be witty or refractory with you, you had better settle that on account with him at first, or its items will increase with the cross-examination. If you have personal vendetta against the witness, don't use the cross-examination to settle scores. Settle them outside. Cross-examination is not a battle of wits. The purpose of cross-examination is to get the truth. That's it. Don't use your cross-examination to show that you are the smarter of the two. That is not the place. Let him or her have an opportunity of satisfying either that he or she mistaken your power or his or her own. But in any result, be careful that you do not lose. This is the most vital principle in cross-examination. Don't use the cross-examination to show or vent anger, or don't lose your temper. Anger is always the precursor or evidence of assured defeat in every intellectual conflict. Rule 7. Like a skillful chess player in every move, fix your mind upon the combinations and relations of the game. Partial and temporary success may otherwise end in total and remediless defeat. This is not a battle of egos. Cross-examination is not a battle of egos. Whenever you prepare for the cross-examination, one of the techniques that I personally use is, first of all, I'll make a list of answers that I want from the opposition, and then I'll write questions that are leading in nature and write them down. The next column, I'll write the expected answer also. The answer that I want is the first column. The questions that I frame to get those answers is the second column. The third column is answers that I may get. And the fourth column is the questions that I have to ask if I get that answer. So always go to cross-examination with these 4 columns. And initially, I would prefer to be prepared, number 1. Number 2 is to go with a printed questionnaire to the cross-examination, because you may forget some questions. You better go with a printed questionnaire to the cross-examination. Next slide, please. Never, ever, ever, never undervalue your adversary, but stand steadily upon your guard. A random blow may be just as fatal as though it were directed by the most consummate skill. The negligence of one often cures and sometimes renders effective the blunders of another. See, even your opposition is a human. They are, and especially when they file a false case, they are bound to make blunders. Keep your antennas open. You will definitely be able to catch up on those blunders. The last rule: be respectful of the court or the tribunal. Kind to your colleagues, civil to your antagonist, but never sacrifice the slightest principle of duty to our overweening deference towards either. Next slide, please. Right, we are done with today's seminar, but the material for further reading is Dr. V. Krishnamachari Law of Evidence, Sarkar's Commentary on Evidence Act, 11,000 Questions for Cross-Examination, and the Art of Cross-Examination. I would recommend everybody who is serious about cross-examination to read these 4 books. Next slide, please. This is my contact info. This the number one is my email ID followed by Twitter ID. Webinars are cross-examination to continue for the next few weeks. Thank you. Next slide, please. Yeah, we are done.
Thank you, Parasa, for a wonderful presentation of cross-examination essentials or introduction. Right now, we are taking questions.
Okay, Mr. Rodolph.
Yeah, there are some questions. Let me, or anyone else is taking questions? Vikas or Ramesh?
Yeah, Rudy sir. I can actually read out the questions from YouTube.
Okay.
Okay. So, yeah, hi Parasa. So we have some questions related to the strategy on the domestic violence or 125 maintenance, CRPC 125. Well, the first question is, during wife cross, what are the sections that can be used to make wife's lawyer out of the courtroom, as the lawyer through his gestures can actually direct the wife what to say and what not to say? Like he will be prompting her how to answer the cross questions. So is there a way where they can actually object to his presence in the courtroom?
I would say use the demeanor of the witness. CRPC 280, CRPC 280 talks about demeanor of the witness. Let the court know that the advocate is prompting her. Ask him to file a memo. The court is not listening, ask him to file a memo. Let the court know.
So we need to bring it to the observation of the court.
Yeah,
Yes.
most of the time the questions are yes or no. He will not like to say yes or no, standing in the corner, and she will look at him and she say yes or no. So we have to inform the judge saying this is cross-examination of the person, not the lawyer, because lawyer is guiding from there. So you can inform the court that lawyer is guiding her to say yes or no. So you ask court to send him out of the court or silence him. Okay, Ramesh,
Yeah.
next.
Thanks, Rudy. Thanks, Professor. So the next question is...
The best way is to make him stand behind the witness, behind her, so that she cannot see to her, see him, see the lawyer. She cannot view the lawyer, and lawyer can object. Lawyer has rights to object, right? So that lawyer can also listen to object the question.
Yeah.
That's it.
Okay, so moving on to the next question. This question is about, can we file application under section 311 for recross by adducing the Supreme Court citations of 1991 Mohanlal's and recent Natasha Singh, which is from Supreme Court 2013, in our application to persuade the court to recall the complainant wife? Might be this is actually to recross again after adducing some more citations from the Supreme Court. So cross normally will be like in 1 or 2 sessions, and in the case where they want to further cross the complainant, what are the means that they can actually look to?
Professor, anything?
Yes, he can do it. Right, but he has to show reasons.
So what is the general practice, Professor? So do you recommend them to actually just make sure all of their cross, at least for the complainant, not for the witnesses, to be completed in 2 sessions, or in case of further new material coming in, how to actually tackle that? We are generalizing the question so that it helps everyone.
If its cross is over, I don't think again recalling is possible. If the earlier this thing is there is some other things are left out or something like that. But once judge decide cross is over, I don't think it's allowed to adduce even the new evidence comes.
Yeah, in this case, the party has to submit an application to the court under section. There are some sections. Yeah, I don't exactly remember to recall the witness. And the witness has right to object the recall, and then the matter goes to High Court, and finally, after fighting the case in the High Court for the recall, the court gives the order that if the witnesses can be recalled or if the witnesses cannot be recalled. Yeah, that's it.
Okay. Yeah, we have the provisions, but the general tendency wise, what should be the best recommendation or the better thing to follow? So better thing to follow is normally to actually mostly assume that there will be no recall later, and to finish off whatever is there in the.
See, he has to give sufficient reason for not finishing off the cross-examination in the before the evidence was closed. Before the cross-examination was closed.
Okay, we'll move to next question.
Okay. Yeah, the next question is how to make contradictory set of questions, and after the cross or evidence stage is done, then how to take advantage of those cross questions in our argument stage. These are quite general in nature.
General in nature, we can answer it with a specific answer.
Okay, then we will actually move on to the next question, because the question, like the earlier question, is more or less like a complete guidelines on how to do cross and how to take advantage of it. Might be the further webinars, whatever will follow on cross examination, would actually help to get answer for that question. We are moving on to the next question, which is about, can CRPC case filed under section 125 be transferred to a metro city or a mega city, and there can be an increase in the maintenance? So the question is basically, there is a transfer to the metropolitan city so that the maintenance can be higher.
There are chances.
It's not
That's
like
why
that. See, its maintenance depend on your salary or earning, and the status and the last stayed together, how you stayed. It's not like she can move it to Dubai and say, here I am paying 5 lakh rent. You cannot claim like that. Okay, it's depend on your earning capacity, the husband's paying capacity, and the way they are live together. Like they were having servant, car, and bungalow separate, and if they are living in Jhoppadpatti and she cannot claim in lakhs. Okay.
Yeah, that's as per the husband's lifestyle.
Yes, just because you want to claim a bigger amount, moving to other city, and it's not like that.
Okay, and even if she moves to the other city, the transfer petition should have a proper merit to be considered.
Okay, next.
Okay, yeah, the next one is a memorandum of understanding has been filed mutually, and even the MCD has been granted. The girl don't support withdrawing the cases, so she is not actually now helping to withdraw the cases. In 498A, a bailable warrant was also issued on the girl. She came and gave contesting statement, like she is now ready to contest the case. What action can be taken against the girl? I think the terms of MOU might have been actually like
See, if his MOU is used in divorce and she is not obeying based on MOU, divorce was granted. That means court is recognizing that MOU is valid, that she is agreed. So if she is going against to MOU and divorce petition, it will be the contempt of court and breach of trust. Okay. And there are other criminal sections also you can add, but these are the main thing you can use to bring that judge. Unless you file something against her using this, nothing will happen. If you are waiting to her to come to 498 and withdraw the case, and now you are saying she is giving contesting statement, then it's against what she agreed. That is again breach of trust. So you can use these two: content of court and breach of trust.
Yep. Thanks, Rudy sir. So the next question is about what are the basic questions to be asked in the cross-examination?
Basic questions depend on your case. It's not like we cannot tell these are the basic questions. They will ask basic question. What's your name? What's your age? Those sometimes they will ask like that just to make confuse you to like you are aware of yourself or not. Those are the basic questions. Okay. Sometimes even they ask what is your date of birth and you are confused totally. Your opponent lawyer or opponent want to make you confused, so you will not give proper answer. So they will simply ask these silly questions to confuse you. Other than that, if you are remembering everything about case, there is nothing to worry about it. You can straight away answer. No need to make funny face or laughing face. Be calm, answer normally, not to be tense. That's it. Because the next question also someone asked what should be the male
Yeah.
facial expression. Okay, there is not like there is a special expression for male and female. Okay, be calm, not to be get tense. Answer
So
point to point.
yeah, I want to add something on top of that question, sir. So how serious is the demeanor taken actually? Like what is considered as the best demeanor of the witness? And yeah, if at all, just based upon the demeanor, how much can it actually like impact the case?
Mr. Ramesh Bhattan, if you remember the previous webinar, talking about the webinar about important points in criminal trial, there was a case where, where the complainant contradicted their own statements given in the FIR. With the chief, it was exactly opposite to what was given in the FIR. The statements,
Or the voice is breaking.
the statements given in the complainant examination in chief and the FIR are self-contradictory, right? And when the client and when the witness was confronted with the statement, like which of these is true, the witness waited for a few minutes and then said the statements given in the examination sheets are correct, right? In such a scenario, you first of all, the counsel, the person who is doing the cross examination, has to draw the attention of the court towards it. Look at your honor or my lord, look at what happened here. There is absolute contradiction, so please make a note of it. He waited for few minutes before he answered. So he was thinking in the cross examination, like, what should I tell? Right? Except in such serious scenarios, frankly speaking, demeanor doesn't play a major role. But when you're cross examining, it is your responsibility to use each and every opportunity to impeach the credibility of the witness. And demeanor is one of the ways to do that.
Okay.
Okay.
Okay, Ramesh.
The next question is about is there any limit on the number of questions in the cross examination?
There is no such limit, because when your opponent or lawyer is asking you or asking the witness, did you murder? And he agrees, yes. Is there any chance to ask next question? He completed his task to make his statement, because asking further question will complicate his case or situation, the client of his client. So witness agrees he murdered. There is no further question to be asked. So there is no limitation. It may end in one question, or he can take 10, 25, 30, 50 questions till he reach his goal to prove you are wrong. That's the opponent intention. So there is no limitation. That's it.
Okay, sir. Yeah, we are actually skipping the question related to the body language of the male in front of the magistrate, which is already covered. The next question is, this is in 125 case, CRPC 125 maintenance case. Seems like the respondent has actually moved section 340 perjury, as he has evidence that she lied under the oath and in her affidavit. However, the 125 case is still going on. Should the 125 be put on hold till the time 340 is actually like trialed and completed?
Yeah, there is one judgment on MyNation, says 490, 340 are to be taken up before, like early. Whatever your 125 is running, then at that time you are filing 340. That should be decided before the 125, because this is related to same case. Then you cannot file 340. You can inform with all your evidence, whatever proof you have. She came to the court with unclean hands, whatever false statement or false affidavit or whatever she submitted. You can inform. It's up to the judge. Take up 340, and he has to take before 125.
Okay. So moving on to the next question. Normally in the case of criminal cases, they will have APP or the PP, public prosecutor, as their lawyer. But in case she brings in a private lawyer, how to deal with that lawyer in the case of cross-examination stage and all this?
Ask the client to ask the person question, asking the men. Ask the person who has posted this question to read Rekha Murarka versus State of West Bengal. Rekha Murarka. You will get the answer.
Sir, you can type that name in chat window.
On the YouTube chat.
I'll do that.
Okay, next.
Okay. So the next question is from Sairam. He says like his wife filed 498 along with sections 34, 3/4 DP Act in the police station. But now my question is, can I file any court case or police case stating that giving dowry also is a crime as per our law? He
Yes.
continued his thing, and OP itself accepted in their FIR. So can I proceed anything on this legally?
Yes, please watch
The
our
webinar
earlier
only.
webinar. It's given by me only. It's on mynation.net/live. All the links are there on DP. You can file if you have evidence without mentioning her FIR.
Okay. So the next question is, my wife is a criminal mind lady, and after lot of suffering, I filed for divorce and my father filed for permanent and mandatory eviction suit. In retaliation, she filed DVC and 498 package. What are the chances of relief in eviction suit by my father? The lawyer didn't make me respondent in that, only wife is the respondent. Can she claim right to residence under DVC?
No, I think before there is one more question.
The one is actually repeat, sir.
Okay.
So this question is basically, seems like there has been a marital conflict, and then the husband filed for divorce. After his filing of divorce, I think his father also filed for a permanent eviction suit of daughter-in-law. seems like the daughter-in-law has filed a DVC and 498. So their question is, under DVC, can she claim right to residence?
If it's a shared household, then she can claim. Because there are many contradictory. Even Supreme Court is not straight away saying she can claim father-in-law's property or not, because one judgment says she can claim and other judgment says she cannot claim. So there also they are not sure. Even our milords are not sure that what to say. So it's difficult to say she can claim or not, because some judgment contradicts. So all the judgments you can find it on MyNation. You can search and read about it.
Okay. But typically, even if she actually claim right for residence, it can't be the same property.
Yeah, it's ancestor. Yeah, that's what. If it's a shared household, then most of the judgments came that she has a right to reside in that
In the same
property.
property. Okay.
Yes.
Okay, sir. Moving on to the next question. So this question is about conflict of dates. Hello, sir. If in section 13, husband's advocate present, then on the same date, husband have to present in 125 CRPC case without issuing summon to husband living abroad. I'm not sure I understood the question, but seems like, yeah, if at all, if there are two cases, like both 13, which is related to the divorce, and then 125 CRPC, and if the husband can only attend one case, what should be done
If
on the
he
other
is
one?
saying husband is living abroad, okay, she has to appoint someone. In a divorce case, he can give power of attorney, because to any of his relative to appear, because they have to pass the information if it comes. If it's in family matters, lawyers are not allowed. So someone from family members can appear for that, and 125 you can contest through lawyer.
Okay. So the next question is about what is malicious prosecution and how to file it. Any brief introduction or insights on that would be helpful.
That is one of my webinars in the next few weeks.
That's okay. If you have answer, you can give answer now, Parasa.
Malicious prosecution, it basically talks about, yes. See, it can be, first of all, it can be filed only after acquittal, and you have to establish in the case that this particular prosecution was done without sufficient cause and reason. Then you may get some relief in the form of monetary compensation, which is again a new case. You may have to run behind the court for about 3-4 years again.
Okay. Okay, we have another question from Sairam. In his 498 case, the current status is charge sheet has been created 5 months back, and it is still showing it's like a charge sheet created. And there's no update in the case. So what can his steps be? So what can he do next?
If charge sheet is filed, then they have to submit it to the court. Okay. We don't know where is shows created. Anyway, he can check with his same jurisdiction court if there is any case on him to see the status, because without his notice, maybe case is running as he says is completed 5 months back, then it should be in court.
Yeah. So we are assuming that the charge sheet might have actually submitted to the court. If there are some findings by the court and the charge sheet could have been rejected, sent back to the police. If that's not the case, probably it's better to check on e-courts, if at all, if there has been already trial started, CC number allotted to the charge sheet.
Yeah, you can search with his name or details. So we will find out is there any pending case.
Yeah.
If it's a 498, then it's a criminal case. It should be listed there.
Okay, so moving on to the next one. This is related to the earlier question we discussed, like on the eviction suit. So when he filed divorce, he has actually mentioned the address at the time of filing as the ground floor of the same house of his parents. Can this go against and hamper relief in eviction suit? So it's actually like a partitioned house, and it seems like the husband has actually mentioned like one of the partition in that house as his address. So she can only ask for residence order within that house of that partition. Anyone who can actually take up this question?
No, eviction should be like his father can evict both, not one, because only daughter-in. When he issue the eviction notice, I am evicting my son. That means she should be followed. But now here there is a divorce or other issues are going on between husband and wife. Then she can claim under domestic violence where she was staying, because that address or property, even it belongs to his father-in-law, even husband also already showing as his address, that is like another proof that they were staying there.
Matrimonial home.
So that's make a different issue again.
Okay. Okay, moving on. The next question is about what are the suggestions in cross-examination and how to use it. I think this is actually quite general in nature, and the basic webinar is related to that. So we will move on to the next question. Dear sir, can adverse verdict can be given by court for interim maintenance if respondent cannot attend the dates in other state because of COVID-19? The case is going for 4 years. 4 years and interim maintenance. Who want to take it?
There's a very, very high chance. What is the council doing there? Is he doing it party in person, or does he have a council? If he has a council, then you never know. What is the council doing?
But actually,
His
the
lawyer
basic
is
question
there,
is,
then he can contest there. No need to be, unless judge ask him to appear for something. Rest of the things his lawyer can appear.
yeah, I think his basic question is still like end of February, can he take COVID-19 as the basic cause for not attending the dates in the court? And if such absence has been observed by the court, will there be any adverse orders?
No, at the last something issued against you, that time if you inform, they will not agree. But for the every date, you can say like that. Now there is a travel restriction because of the COVID. You have to inform every now and then. It's not like in some cases non-bailable warrant issued after 6 months or a year for non-appearance. Then you cannot say no, there was a COVID. You cannot tell like that. So you have to inform, update even police or court as per the dates comes on every date. You have to inform through your lawyer that there is a travel restriction. Not after they issue something against you.
Okay.
Okay, next.
So the next one is, in a recent court hearing, my lawyer asked the judge to record a statement of opponent lawyer who was lying a lot, but the judge did not record in the order sheet. What can we do in this case?
The council is just the representative
Case
of
is
the
not
party.
between lawyers.
Sorry, Rudy sir, can you repeat?
Case is not between lawyers, and lawyers cannot tell anything, whatever he thinks, like lying in the court. It's not like that. It should be related to the case. And if it's not related to case, he's just telling something, then you can counter there itself. No need to wait for something. Okay, justify. You can ask judge to make a note. He has to answer this, whatever he is saying. Judge is not recording, then you can make an appeal in next date. That last date he was telling like this, to make a record that you want a clarification or a justification or proof for whatever he said. Just to mislead the justice system, he cannot tell anything without valid reason, valid grounds, or supporting documents or evidence.
Yeah, actually, this is the case most of the times. Like the opponent lawyer keeps saying something orally, and that never gets actually recorded on the order sheet.
No, even that is not valid because no one is recording. It's not coming on the file. Okay, so
Yep.
you can ignore also because they can tell anything.
Okay.
Okay, if it's not recorded, this is not a valid point to argue on that later stage.
Okay.
So, he is barking, let him bark.
Just because they are all lies, probably the like the question here is, can we actually capture it on the order sheet and or case sheet and then
Yeah,
take
that
advantage
you
of
have to
it at a later
show.
point?
That's what you are saying. He is misleading and diverting the justice system, wasting resources of legal system. That you have to show in a written. So make him silent. That next time onwards he will not tell anything without valid reasons or grounds or evidence or proof.
Okay.
Okay, next.
Here we have a question from Lakshmikant. Can cases be transferred to another state on the grounds of disability of husband and also the disability of son residing with husband? Seems like the custody of the son is with husband here. The cases on him are DV 498A, divorce, interim maintenance, and custody of mentally challenged son, whose custody is with the husband.
Yes, if you have valid reason and there is a judgment also, court has to look into both parties' convenience. It's not like one party's convenience. Okay, if really there is a reason to transfer, then you can appeal, even it's a different state. Then sometimes court order, or you have to pay travel and other expenses, or exempt other party from appearing from every date. That also possible. It's not possible. Justice should be equal to both. It's not like one person's convenience that just because I want, I can transfer here. It's not like that. If you have valid reason, ground, you can always make a petition to transfer.
So a transfer petition can be filed even by the respondent if at all, if the grounds of the transfer petition are quite good enough.
Yes.
Okay. We have next question from Sairam. His wife is actually working, and after 1 year of marriage, she started transferring money like around tune of 25,000 per month to his account, and she would actually withdraw that from the debit card and use it for her expenses. The question is, does this actually create any issue in 498 case? Because she is doing the transfer and cleverly withdrawing from his own debit card as cash and using it for her own expenses.
No.
Let us see what she has written in
started
the
to
FIR.
transferring money to my account, and up to 2 years plus, she was using my debit card for withdrawal money for her monthly expenses. That means, yeah, she is sending, she is withdrawing. There is a both debit and credit and debit.
No. See, the withdrawal is from her husband's account card, sir. So for the
Yeah,
code,
the wife is playing cleverly over here. The wife is playing cleverly over here. She'll say that the husband and his family pressurized her to transfer all her salary, or at least 25,000 of her salary amount, to his account, and he is withdrawing by that debit card
Yeah, because
that
withdrawal
she
on the
will
debit
be
card
claiming.
will not actually
Yeah,
like.
that she will be claiming. So,
Again,
so the
there is
husband
a
here should,
clear bank guidelines. No others cannot use others' credit or debit card, right? How she is using?
yeah, and the husband here can collect the evidences of money withdrawn from the locations, and he can prove that he was not present in that location where the money was
No.
withdrawn.
Every ATM machine has camera. There
Camera.
is a this thing he can get from that bank also. There is evidence. She is withdrawing. Other than that,
Yeah.
also he is again has problem with this. Then he can if it's his card, then he can cancel his card.
Yes.
Why he is allowing giving his card?
Yeah. At that time, the wife was playing cleverly, and the husband was not aware that she might go for filing the cases. So she'll be misusing the information when the terms were right, clear in between them.
Yeah, that means she planned earlier, and he
Yeah.
was
So
dumb
she
to give her credit card, debit card, whatever.
yeah. So she planned that cleverly to misuse in the future. So now the husband has to collect the evidences of everything.
No, even bank is not keeping for 2-year-old screenshot or videos of ATM machine.
Yeah, so bank is not keeping. So he can get the details from which ATM the money were withdrawn, and also from
That is a lengthy
and
process of CDR
yeah,
and
that is
other
the
things.
yeah, that is the lengthy
Again,
process.
CDR will not prove in this case because you keep your mobile at home and you are going and withdrawing. They can say at that time I was in that city. So it's difficult to prove with the CDR also. He can
Yeah, it's
report it to
difficult to
the
prove,
bank
but he
and
can
cancel.
he can report it to bank right now if the same is happening right now.
Yeah, if it's still she is doing same thing, then he can cancel his card.
Yeah, and he can also say that the card was misplaced.
Not misplaced, stolen by her, and there can be actually a case of
Yeah,
420 also can be filed.
yeah,
Yes,
forgery.
all money is withdrawn. Let police do investigation and let her come and give statement that she withdraw the money.
Okay,
Yes,
so we
make
will.
evidence from his side.
Yeah.
Okay.
So moving on to the next question, seems in this case there has been a CRPC 125 case filed by the opposition, like a wife, and she could not actually prove her allegations for CRPC 125. The husband is asking, can this be a merit for filing a divorce? Like, can a divorce be filed based upon these observation to the court? Like, she filed a 125 and then she did not actually prove her allegations.
No, 125 is for maintenance case. Maintenance case cannot be used because divorce grounds are different. Okay, there are various grounds for divorce. There should be separation. There should be cruelty. There should be disease, or there should be bigamy or adultery or something else. Not on maintenance application. If she is
Yeah,
giving false allegation, okay, those allegations you can file appeal for a 340 in 125. If she proved, if you are able to prove the 340, then that will be the ground. Like she came to the court with false this thing harassing you, and she filed all the false allegation telling lies about you. whatever. If it's defaming you or something else, also you can file all those additional grounds for the divorce, not the main ground of the divorce.
Okay. So the creality,
Yes.
just because she has actually filed a CRPC 125, is not like the main ground, but it can be still considered. Okay. Okay, moving on to the next question. Before sending husband in judicial custody under section, like in the execution petition of CRPC 125, what are the sections that can be used to protect husband from going to jail, and how much will be the period of judicial custody? It should not be judicial custody, if at all, if the husband execution petition sentences him. Okay, I'm not sure, but yeah.
Before that, there is one Lakshmikant question is there.
I don't know, it's not a question. Like there is like some conversation between Vikas and Lakshmikant. Vikas has actually asked whether he had filed the cases, and he clarified that he did not. He's only trying to file a transfer petition. I think he has already filed a transfer petition because
If
he
it's not
has
filed any case, then what is transferred?
No, wife filed all this DVC maintenance and all those cases.
Okay.
Yeah, we are actually at this question where an execution petition is already filed, and the question is about what are the sections that can be used to protect a husband from going to jail, and how much will be the period of sentence normally, if at all, if the execution petitions gets allowed.
No, when there is a jail term of failure to pay her, there is no special law for that to protect you unless you pay. Paying is the only option can protect. Okay, and you can argue further. Most of the time, they will ask you to pay half. So they can take up your question, objection, whatever you can file later and contest that to justify the order. Not just like that using some law sections to protect husband. It's not like that.
Actually, it is better to fight the execution petition itself, if at all, if the grounds for the petition.
No, he is saying he will not contest, or there is a already execution petition also filed because there is a pending arrears and he is not paid. That's why the execution petition is there. So we are now execution petition, he is not able to pay, then he has to land in jail. So he want to protect. That's what he is saying. Husband from going jail. How much period? It's 1 year. Anyway, even 1 year, that's what. If you are paying half, then you can file a appeal to contest the 125. Why it's awarded and all that. If you have valid grounds for that. Other than that, there is no law just to protect them.
Okay. So we have the next question from Lakshmikant. He's asking for, if at all, if there are any citations that he can use in case of transfer of case, a transfer petition, which is in favor of
you
physically
can
challenged.
search on MyNation transfer petition. You will find, but it's not a challenge person because it's a various other grounds also there. Or based on that, there are transfer judgments came. You can search with the word transfer or transfer petition. You will find some judgment.
Okay. So the next one is, during cross-examination by the OP's lawyer, does one get a chance to elaborate on a point beyond saying yes or no?
Yeah, mostly they will end up closing these questions with yes or no, and that's how they are making those questions, because there is no time to explain unless there is a real scenario to say something. Then you can ask judge to explain why you said yes, why you said no, why is no. Then judge says, okay, go ahead. Then you can explain. Otherwise, most of the questions, yes or no.
Okay.
Okay.
Yeah, like this is again continuation of the earlier eviction suit question. Here seems the property is actually self-acquired by the father. Still, if that is shown as a matrimonial
Father
home,
can
evict
acquit,
both of them.
not ask you to disown son and evict both of them,
Yeah.
not only daughter-in-law, both of them. And it's a husband responsibility to give roti kapda or makan to his wife.
Okay. In continuation to the earlier question by Vaibhav, if we file divorce and if opposite party do not want, then how can we proceed and get divorce? Like in his case, as we discussed earlier, wife filed has CRPC 125 and could not prove her allegations. He thought like it is better, like enough merit.
Your
Divorce also,
cases should
Sorry.
depend on
should be valid
Mr.
grounds. Sir?
Yes, Mr. Rodolph. I will answer this. First of all, your case should depend on your own feelings, on the strength of your own case, not on the weakness of the opposition case. So what if the wife says no? Let him, let him plead properly. Like, let him explain how he was subjected to cruelty, how he was deserted without sufficient cause. Let him plead everything in the petition, and let him support it with necessary evidence. There is a very high chance of him getting divorced.
Okay, we'll move on to the next question. This is again by Lakshmikant. His wife has actually left after 7.5 years of marriage. She left mentally challenged son with the husband. While leaving, she gave an affidavit to the police station that it is her decision to go away. What cases can be filed against her?
You can file maintenance for the son.
And if he wants her back, RCR.
Hmm?
He just asked like for all the cases.
She gave and she gave in writing, that is an affidavit, to the police station. There is no question. They're asking her to come back, send her RCR or something like that. She left. Okay. If it's 2 years over, you can file for the divorce based on that affidavit that she left, deserted you without any reason.
Sufficient cause.
Okay. And there should not be any maintenance, because there are many various judgments from High Court to Supreme Court. Those who desert husband without valid reason are not eligible to claim maintenance. Now she left not only husband, the challenged son also she left. She don't want to take responsibility. She want to escape from this marriage. So you can file a maintenance for son.
Yeah, maintenance of the children is responsibility of both the parents, so she should actually like contribute to half of his maintenance, and he can actually file for maintenance of son. Okay, and the next question, yeah, it's again like a continuation for what Sairam has said earlier. In EcoTap, when he checked, it shows that the police have not submitted 498 case to court still, and it has been 8 months now. What I got to know is OP stopped to submit charge sheet to court currently. Political political background. So what can I do in this? Who want to take this question?
If the police is not sending it to the court, so trial will not start. Maybe they have other reasons to not to send. Okay. They may be not sure that they can send it, like showing that it's completed, or we don't know. We cannot ask to submit police to submit it. It's up to them. So no need to be worried about it. So still you can keep your this thing app, ePort app, to check your case status. If anything comes up, you can appear and contest or do something. You're not
Yeah,
supposed to
continuation
submit it.
to his current question. With respect to 498A, I called my wife's relatives to get the evidence, but my opponent side lawyer called me and shouted like, "You are not supposed to call anyone. If you want to tell anything, then you have to talk to me only. Otherwise, I will file another case on you," like this OP lawyer was telling, and I have call recording of same. Can I do anything on this as per legally?
Yes, you can report it to
First of all,
BCI
ask him to
Bar
keep
Council
quiet.
against this lawyer. And you can even he cannot give threat. He can file a complaint also. He cannot threaten anyone. Depend on like I will file a false case or whatever, unless he has valid reason and ground and proofs. Just because you are calling, okay? Report it to BCI.
Bar Council. Okay, yeah. The other questions that are there in between. This is from Darshan. Judge warned him to pay all the arrears within 7 days, or he was said like they will issue an arrest warrant against him. It's mentioned in order sheet too. I have appeal pending in High Court. He know that, but as don't have stay, they force me. So in this case, yeah, like I think on the execution petition, the judge said like all the arrears has to be paid in the next 7 days. And the respondent has actually appealed, and the appeal is pending in High Court, but there is no stay as of now from the High Court. Like there is no order yet. And the question is, can they really force him? Can they or not?
Yeah, judge can do that. Judge can issue non-bailable warrant, and they will now they are doing to support women. They will attach your property and other things also if you are not paying. Okay. Again, you can make an appeal that this thing is pending in court. Same thing you can report it to High Court also. That even the pending is case is pending in High Court. Judge is not ready to listen. You can report against this judge.
Okay. Okay. The next question is related to the video conference. Can cross-examination be done by virtual hearing? Is it advisable to do cross if court permits video conference?
If court permits, everything is possible.
But is it advisable?
No.
My answer to this is how technically knowledgeable is his own counsel. How patient is his counsel. It all depends. It depends on those two factors.
No, even virtual, she is sitting somewhere, and whatever questions it comes on her PC, and someone is telling what to answer. Okay, maybe our lawyer sitting next to her place, who is not visible to the video, but he is telling, okay, answer this, yes or no. So it's not advisable to take up any cross on virtual video conference.
Okay. The next question is again from Lakshmikant. He confirms like his petition for transfer has already been filed in High Court and the transfer is not yet done. Wife is fit. He is actually handicapped and work as a teacher. My absence for court affects students. Can this be genuine ground for transfer? Like he's saying like from the point of his work nature, he can't actually take too many absences because that is impacting the students. Hello.
What is the question?
Yeah, this is related to the transfer petition by Lakshmikant. Earlier, he was actually discussing that, right? So, in his transfer petition, it is already in High Court and seems like it's not yet decided. But he is saying because he works as a teacher, can his absence be also mentioned that it will impact students? So the transfer petition be dealt. And
Yeah, it's another point. Not only the teacher and affect the student, but his son also there. He is saying his challenged son. That should be the main reason, not the student. Okay, and that is the additional point to your to claim your
support,
transfer petition, support transfer petition. Not to make this as a main ground for that. Okay, care of your son is important, not the student. Okay, if one student miss one teacher, then other teacher can take over and take the class, or you can take it later.
Yep.
Okay.
The paramount interest must be the son or the child here.
Yes.
Okay. The next question is from Sairam. क्रॉस एग्जामिनेशन करने का कोई टाइम लिमिट डिफाइन है क्या? So is there any time limit for doing the cross examination, like within first 1 year or 2 years, or as per the stage of the case?
Sir.
Hello, Parasar.
It's gone.
Okay. So as far as what we know, yeah, there is nothing like a time limit.
Okay.
Madam,
Moving
can
on
you
to the
please repeat the question? Yeah.
The question is cross examination करने का कोई time limit define है क्या?
कोई time as such no time limit is defined for the cross examination, but you can always approach the judge verbally that from these many times the petitioner is the respondent is attending the court regularly, and opponent is the petitioner is taking unnecessary adjournments and delaying the cross examination and avoiding the cross examination. So can it be like just request to expedite the thing, and the judge will itself do the cross examination and close the cross examination, or bypass the cross examination stage? That actually happened in my scenario.
Okay. Okay, moving on to the next question. Can father-in-law sign MOU on behalf of his son with wife without power of attorney of husband? Can wife ask full and final alimony from father-in-law? Husband is living abroad. No. Actually, yeah.
Yeah, even he is living abroad, he can sign, he can print there and get it signed and notarized by Indian Embassy and send it across. Okay, that is a valid.
Without power of attorney being certified in India, father-in-law can't sign for divorce or MOU. Can I be made a respondent in the eviction suit now? The issues are already framed on the last hearing on 4th February. This is again like continuation of the question related to the eviction of property filed by the father of husband. I'm repeating the
We
question.
can add in same this thing that father is evicting both of them. I
Okay.
don't want my son and his wife. He is not directly telling daughter-in-law. Before it was daughter-in-law only. Now he is saying my son has no rights over my property, and I don't want, I disown him, and I want to evict him.
Okay. Yeah, now he can be actually added as a respondent, another party in the same petition. Next question is from Sandeep. The petition for 125 maintenance, like I think we discussed this case earlier, like where 125 has been filed 4 years back, and now if at all if there is any threat for interim maintenance, and if at all if he is absent, mentioning COVID-19 as the cause. The petitioner for 125 maintenance case for the past 4 years did not press for interim maintenance, and was more interested in getting the IT details of respondent. Recent communication with IT department has denied sharing of personal details. The child is with respondent and is medically unfit and taking care. The petitioner has no liability. Will these factors play a role in maintenance?
Yes, child is with the father, then he can always counter the her petition. Like earlier case, challenge son is with father, and for son also he can file a maintenance, asking maintenance from the mother.
Yeah, and he is also
Counter her maintenance that she left son also without valid reason, and son is you are taking care of your son, then it's a valid ground not to give. You can fight it out. It's not that nothing comes by default unless you do something that to prove that the child is with you and you are maintaining your son also, and she is not ready to take any responsibility.
okay. And he also mentions, like, can he ask the court to actually close the case with final maintenance instead of interim maintenance, because the case is actually running for 4 years long? I think yes, he can.
Okay, next.
What's the best time to do cross-examination? Court has asked my wife to produce evidence on next hearing in domestic violence case.
Yeah, for this take stages, it's not like as soon as court your case begins, you cannot do cross examination. There are the steps of every legal proceeding. When your cross examination time comes, then only you can make a cross examination. You are not just because you want to do in beginning. It's not like that. You have to submit your evidence, her evidence. There are many stages, and it will take time. Okay, next.
Okay, next question is from Prem. Is it mandatory for wife to produce bills or photos if she claims her Stridhan is forcefully kept by in-laws? So far, she has not submitted any bills of the jewelry items.
Yeah, she can bring many jewelries, but she has to prove it that it's with you. How she will prove? Is there any photo wearing those jewelry and at home or some function? Still, it's up to her to prove it. It's with you, not just because she will bring, because many are producing, one lady produced some 10-50 pages of all lenga chadar whatever, all the these things she produced, but there is no proof that it was she brought all those things to husband's home.
Okay. Next question is from Vaibhav. What are the precautions or preparation before facing cross-examination? For me, I filed divorce case, and his mother and other independent witnesses has been mentioned on that case.
See, not to worry about cross examination, not to be tense. I think there is an article I wrote about cross examination, how to do it. Okay, if you are in group, I can share later in group. Rest you can ask Farah sir is there in a group. You can ask him directly. He gave email and Twitter ID, and you know his number. You can ask him.
Okay. The next question is again from Lakshmikant. I will just take this one. For the rest of the questions, Lakshmikant, it's better you actually write down your questions or seek support from the WhatsApp group. He mentions, like, his wife's lawyer does not allow him to talk to his wife. I'm a professor. He demands me for 12 lakhs lump sum and 12% of salary per month for settlement without giving me a younger son, which is mentally sound. So he has got like 2 child, and the elder one is with him, who is having a challenge, like physical challenge, and the younger one seems to be sound healthy, and the younger one is with the custody of the younger one is with the wife.
Yeah. Now elder one is the challenge one with you. Then you can file maintenance for him, as said earlier. And if there is a judgment on MyNation, if mother and children left without valid, she take away the children also. There is a judgment on MyNation. You can check. Both are not eligible claim any maintenance. Okay, read that judgment. And hope, I think you are in group recently joined yesterday or day before yesterday, and your case is in Goa or somewhere, I don't know. You can post that question in group. I'll post that link. Both mother and children are not eligible to claim maintenance, so you can counter her petition, and you can file your petition asking maintenance for your challenged son.
Okay, moving on to the next question. This is from Chandan. He says he's divorced and have a daughter, and he's paying the maintenance every month. The daughter is now 13 years. How many years the maintenance has to be paid as in CRPC 125? No timeline mentioned in the court order. Maintenance to wife or maintenance to the child is not clear.
Yeah, daughter, even she can ask till she get married. She can ask for the maintenance. There is no limit for a girl. Okay, if she's not getting married, then you have to pay. Again, that's what. If she getting a job, then you can counter that. That she can now able
Maintain herself.
to maintain herself. Once she's done finish college and getting job, then you can counter that also. And she's not there are other issues like she's not meeting you or talking you or treating you like a father, then you, that also another ground that mother is training her against you. Okay, there are many various points also there, so we can check on MyNation. We have almost like 50 judgments just on maintenance, no maintenance. You can just search on no maintenance word, you will get many judgments. Go through it, why those maintenance are denied. So you can use those in your case.
Yeah, I would like to add on top of it, sir. If at all, if it is for the daughter and if the court order did not mention anything, you can actually assume it will be only till she turns into an adult, like 18 years of age. There are orders where it has been explicitly mentioned, like the maintenance has to be continued till the marriage of the daughter. Even in that case also, you can actually file change of circumstances, like when she gets employed and she is actually earning herself and so on. If it is for a wife, if at all, if she got remarried, then yeah, you can actually do that. Or if she got employment somewhere else, even that can be considered as a change of circumstance and you can file it. The next question is from Sonu. I think we are actually at the end of the call, so we'll take just one or two more questions. Yeah, I think we discussed about his question even earlier. He is mentioning like the wife lived most of her time 6 months with husband in abroad, and in India she lived only 2 months. What address we should write in our reply? Should write Indian address? She wrote Indian address.
Which is what is the question?
This is actually in continuity to his earlier question. In this one, he just mentioned like wife lived just like most of her time 6 months with husband in abroad and is in India. She lived only for 2 months. And his question is what address we should write in our reply.
Where she is now?
She might be in India. She has filed all the cases, so she is in India,
Okay.
of course. And she has
Indian
written
address
even
also.
Indian address. She has written Indian address. The question is
Whatever
about
address
him.
she gives, that address only, and if you know where she is, which address, you can add that address also. Why you are sending the foreign address if she is not there?
It's a request to all. If you are mentioning any question, please be more precise and specific and copy all the question in one go.
No, because there is a limit to write. the word limit is there, 200 this thing. So you can make multiple and write somewhere and post to one by one. So we can make it. It's your question. Anyway, it's the
Okay.
end of the session. Please take rest.
Yeah, the last question is, are we expected to do cross-examination on the same day when wife is going to share her evidence? So evidence and cross-examination on the same day.
No.
How would I know if my lawyer is capable enough to expose my wife during cross-examination? Also, can we request a court for cross-examination multiple times?
See, questions, most of the questions, if you want to expose her falsehood and whatever the case she is filing, giving statement and other things, then you can draft the question and give it to the lawyer. Instead, otherwise lawyer will ask silly questions and nothing happens. Okay, you can, and if you are uh, able to question face to face, then it's better. You can request a judge also. For more details, you can contact Bharat, Dr. Bharat. He will tell you how to do it. Okay, just send him the message, or if you are in group, you can ask him. If he's free, then you can call him and check for the answer. There is nothing to expose. It's like bringing out the truth. That is a cross examination.
Okay, I think that's the last question. Thanks, everyone.
Okay. No more questions, right?
Yeah, that's it, sir.
Okay. Thank you, everyone, for your wonderful questions and sessions. With this, we are ending our this week's webinar. We'll continue. Any questions? Those who are in MyNation WhatsApp group, you can post it in WhatsApp group. If it's cross-examination questions, then you can post it to Farasar, Dr. Farasar. We will answer your questions. And those who are new, not with MyNation, then please register and you can join us. We will answer your questions. It's free, no charge. We are not charging like other MRI groups. All support and advice is free of charge. Thank you, everyone. And thank you, Dr. Parasar, for wonderful cross-examination session. Dr. Vikas Rawat and Ramesh Vardhan and Vikrant Panur. Thank you very much.
Thank you, everyone.